Hi, it's Mike DelSignore. I want to talk about a case involving Miranda rights that's before the United States Supreme Court. There's a petition for certiorari from a case from the 11th Circuit involving whether post-arrest silence is admissible in evidence. So to understand this issue, I'm going to just talk about pre-arrest silence and post-arrest silence and when the court will find Miranda applies. Now, pre-arrest silence, the U.S. Supreme Court would allow this type of evidence in if the person doesn't invoke Miranda. So in the case of Salinas versus Texas, the U.S. Supreme Court says you need a specific invocation of Miranda rights. So if there's silence pre-arrest, it's going to be admissible, at least under the United States Supreme Court case law. Now in Massachusetts, I think our courts take a more liberal view of Miranda and the Fifth Amendment, and we've interpreted the Fifth Amendment more broadly than the U.S. Article 12 rather, more broadly than the U.S. Supreme Court has interpreted the Fifth Amendment. So Massachusetts pre-arrest silence still could be inadmissible under various grounds. So I would still challenge that in Massachusetts. I think our courts are likely to keep that type of evidence out. And the reason I say this is in the context of post-arrest silence. There's a case from the U.S. Supreme Court involving this specific invocation of Miranda. It was the Tompkins case from 2010, where the person was silent for 2.5 hours, and then finally they made a statement. And the argument was they invoked Miranda by being silent. That's where the U.S. Supreme Court came up with that. You need to specifically invoke Miranda for the rights to apply. And they found that he hadn't specifically invoked Miranda statement that was admissible. Now, our SJC in Massachusetts and Commonwealth versus Clark said we're not going to necessarily follow that logic. When it's ambiguous of whether a defendant invoked Miranda, we'll ask the police to clarify and to ask for further details whether the person intends to make a statement. So our Supreme Court just won't let the police take advantage of ambiguous statements. But getting back to this case from the 11th Circuit, so you have the person's under arrest, and the police then use his silence prior to Miranda rights being read. And the argument from the judges that upheld said that was admissible was that he didn't invoke Miranda. Now, there was a dissenting judge who disagreed with the reasoning, but still upheld the conviction, basically saying the evidence was overwhelming. And her reasoning is really what we should adopt as defense lawyers, that if someone's under arrest, the timing of when their rights are being read shouldn't control. Miranda rights aren't created by the police. They exist. The person's Fifth Amendment rights exist. If the police delay in advising them some of their rights, there shouldn't be an incentive to do that, to get further incriminating statements. So there's a split of authority about post-arrest silence and when that should come into evidence. And maybe the U.S. Supreme Court will resolve it. Our U.S. Supreme Court has been sort of narrowing the scope of Miranda. So I'd say we may not want this case to go up yet on certiorari. Hopefully, maybe a similar case would go up in a few years, maybe when the court composition changes. But in any event, those are some issues when you have an issue of Miranda in a criminal case. You have when if it's silence, is it pre or post arrest? So Miranda rights, as many people know, come from the U.S. Supreme Court, Miranda versus Arizona. For Miranda rights to apply, one, the person has to be in custody and they have to be interrogated. So custody means the person their liberty is restrained in a manner equivalent of that of a formal arrest. So let's talk about a situation where Miranda rights may not apply. You pulled over on the side of the road, the police officer asks if you had anything to drink. In that, the U.S. Supreme Court has said that's not custodial at that point. Your liberty's not constrained, that's just investigatory. Let's keep the same context of a roadside stop, a DUI. Let's say you've now done the field sobriety test. The handcuffs are going to come out, and just before they come out, the officer says, How much have you had to drink? Why don't you tell me now you failed the field sobriety test? Now that may be custodial at that point. I've had that statement excluded because at that point, the police no longer investigating. They're about to arrest you. Your liberty's restrained in the manner of formal arrest. You also get Miranda situations. The police invite somebody to come down to the police station. Sometimes they may say, "Oh, you're not under arrest." Are those situations similar to custodial interrogation? Another situation comes up often: domestic assault and battery. Police come, they ask the husband and the wife, they separate. What happened here? Often that's not going to be custodial interrogation. It's going to be investigation. So keep all these things in mind. Miranda rights can make the difference between winning and losing a case. Certainly, statements of a defendant are key evidence of a crime, and the jury's going to put a lot of weight into that. So in many cases, as defense attorneys, we're going to make the case more defensible, we're going to need to exclude certain statements from evidence. If you have questions about Miranda rights, whether you're a lawyer, whether you're charged, feel free to contact me. I love helping people understand the law and helping attorneys, helping people charged. That's what I'm here for. So feel free to call. It's never too early, too late to call. You can reach out on social media, or here's my cell, 781-686-5924. Hope everyone has a great day.